So hello everybody, welcome again. It's again the last Wednesday of a month. So it's high time for the next Swiss patent litigation fireside chat. It's already the 26th edition. I have shared the agenda upfront on LinkedIn. I will pretty much stick to that agenda. But as always, if you have questions, comments, please feel free to leave a comment in the comments section on LinkedIn. I will have a look at that and pick it up if I see that. Otherwise, I will address that later on as a reply in the comment section. But a discussion, of course, is always very welcome. So let's directly dive in. The first case that I brought with me, I will share my screen right now. That's a judgment of the 31st of August this year. That's infringement litigation between Lüdi Company and Wobatech. Disclosure notice upfront. I have been involved in that case on behalf of the plaintiff, and the time limit for an appeal is currently still running, so I won't talk much about the nitty-gritty details of that case, but rather just give you an idea of what's it all about. So the case is about a so-called service ceiling for laboratories. You can see that in the middle of the screen on top over the workbenches of the laboratory. It's a common problem in laboratories to put all the supply lines in proper order, supply lines for gas, air conditioning, water, and so on. You can see all these supply lines on top of that image. The two rectangular boxes on the left and on the right are the air ducts for the supply of air. And yeah, that's pretty much the overall purpose of that patent that is at stake. I will show you a drawing that is from the attacked embodiment of the defendant. It's all about a support frame for that service ceiling. That frame has a central beam that is vertically arranged. You can see that in the middle of the screen right now. It runs from the ceiling of the room to the very lowest end of the service ceiling, and then you can see also horizontal arms or beams of that support frame that are running from left to right, and you can again see these rectangular boxes, which are the air supply ducts. Now, to give an idea of what the claim is all about, I can show you the claim. Here's the claim. I have marked up the essential features that were decisive for the case. First, in yellow, there is this air supply duct that extends substantially flush with the underside of the support frame in the plane of the support frame. Now, what is the plane of the support frame? I marked that in light orange, a little further above. It is the first plane at a distance from the ceiling of the building. Now, as always, geometry is plane fun. Where is this plane? And this was in the end decisive for the case. I will show you again the drawing of the attacked embodiment. Now, if the plane would be running through these horizontal beams, then this is a non-infringing embodiment. If this plane that is at stake there in the claim, if it would run through the lower end of the support frame, which is where the vertical beam ends, then of course it would be an infringement. So that was the decisive issue, and the judgment says that the plane at stake is running through the horizontal beams. Accordingly, the judgment held it's a non-infringing embodiment. yeah, as I said, the time limit for an appeal is currently still running. The judgment is silent about validity of the patent. It's not that we did not talk about that, but the judgment is just silent about that because it could rule on the issue merely by denying an infringement. So that's the first case that I brought with me. The second case is not yet a decision. It's just a hearing that I attended on the 14th of September this year. That is the case O2022-002. This is litigation between CNE Fein and Robert Bosch on the one side as the plaintiffs, and as a defendant, it's Coram Tools. And if you think that that's something you heard already, you're probably right. That's a pretty old case. There was an infringement case pending at the Federal Patent Court that has been decided in August 2021 already, where the Federal Patent Court issued an infringement judgment holding that there is an infringement. And that went up to the Supreme Court, and the Supreme Court confirmed that judgment in February of the next year, in 2022. And now this case popped up again with a different case number, and now it's it's about damages. And I can show you what this case is all about. It's about these tools on the right, which are, well, cutting tools. And the interesting part is on the right side. It's about the geometry of the fitting where the tool is mounted on the machine. I just realized that I put here a hexagon, which is not what the first judgment was all about. There it was about now this is a heptagon, and the judgment was all about a hexagon. So now I got it right. And this heptagon then was an attempt of the defendant to get around the patent, but this then later, in my understanding, failed for other reasons. There are other patents around that also protected an uneven number of corners in the fitting. But be that as it may, it's now all about damages. And the interesting part about that is what I got from the hearing is that the plaintiff aims to collect defendants' profits based on Article 423 of the Code of Obligations, Geschäftsführung ohne Auftrag in German. And it's established case law of the Supreme Court that this requires bad faith. So that's what this case is all about plaintiff trying to show that defendant was in bad faith. And I've heard arguments in favor and against that. You can imagine. So in an attempt to quickly summarize the outcome of the infringement case, of course, there was also a nullity plea in defense, and the plaintiff defended the patent in a very, very limited way. Various dependent claims were combined, and preferred ranges were used, where not even the outermost endpoints were chosen in any case, but sometimes the upper and the lower limit combined. And so it was a pretty lengthy and difficult combination of dependent claims. And that is, of course, defendants' arguments that, it is not bad faith. We could not expect to end up with a claim like that. I heard arguments from the plaintiff essentially saying, well, we sent you a warning letter. We were exactly pointing to these dependent claims, so you can't be that surprised about these claims being at stake. So that will be a very interesting decision when it is being issued. I think it's a first case that proceeded that far at the Federal Patent Court in terms of damages. Normally, parties just conclude some sort of settlement, but this case is pretty pretty advanced. We had the main hearing in that case, so we quite likely will see a decision on that, which will be highly interesting. We will learn what is really necessary in order to establish bad faith in order to collect profits. That will be really interesting. That is just a sideshow. At the day of the hearing, when I was sitting outside of the courtroom, I got this notice on my mobile phone that the oral proceedings will be starting soon, and that Mark Schweitzer will be there. Mark Schweitzer is the president of the court, and he of course was there. Which brings me to the reason why I got that message. The Federal Patent Court is not since long on LinkedIn. They left Twitter, X, and they are now on LinkedIn, and I definitely recommend to follow the Patent Court's LinkedIn page. They provide updates about proceedings. They publish judgments there, and they also announce events, as LinkedIn calls that. And one of these events is a main proceedings, a main hearing, and that's why I got that notification on my mobile phone. Yeah, that's that part that I wanted to talk about. The next part is about the annual evening seminar, where Tobias Bremi, the second ordinary judge of the Federal Patent Court, provides some insight about the case law of the last year, and that's one of the very few must-attend events, I would say, in Switzerland if you're into patent litigation. I have been there, and it has been a really great event. I won't tell you everything about that event. That would be much too much. But just a few takeaway messages that I wrote down, that I found the most interesting ones. I think that's worth to just give you an update on that. So first, one thing I should say. The event is always under Chatham House rules, meaning that one is of course openly discussing everything, and that one may use and may talk about what has been heard at that event, but I won't assign anything that I have heard during that event to any person. So you can do whatever you want with the information that you get from me now, but I won't say who said what. It's all the product and then my notes from the discussion that I had over the course of the event. So back to my notes. The first was ex parte orders. When you request an ex parte order to be issued, you of course should do that quickly, because otherwise there is really no reason for the court to not hear the defendant when you have been lazy enough to just sit on the issue for too long. Then in that time that you more or less wasted, one could have heard the defendant. So that's the ratio behind that. And just as a quick reminder how quick is, ideally you should be quicker than 2 months after having become aware of a certain underlying fact that requires the ex parte order. So 2 months is okay. 3 months is borderline. There may be cases where it's still okay, but it's already risky. And anything that is longer, it's essentially a no-go. So if you have knowledge of a certain fact for, I think in case S 2022-007, it was 5 months. That was definitely too long, and that request was dismissed for that reason alone. So take home message, be quick means within 2 months. Exceptionally, within 3 months might be okay, but you might have a hard time to argue that, and anything else you can essentially forget. Then we have discussed whether an abstract risk of first or reoccurrence of a patent infringement is sufficient for a preliminary injunction or any other order. And generally, this is not sufficient. And as a reminder, a market authorization for a pharmaceutical, even if a generic has obtained a market authorization for a pharmaceutical, that is not yet sufficient as a risk of first occurrence of an infringement of the underlying patent of the originator's product, because it just gives you the right to market a pharmaceutical, but it's not an obligation to do so. It's just an abstract risk, but yeah, life is risky anyway. So that is not sufficient, but there is one exception, at least to date, it's the only exception, which is a register freeze, meaning that the court issues an order to the patentee or applicant that he must not assign or abandon a patent application that is at stake, for instance, in assignment proceedings. In case of such register freezes, the mere abstract risk that such an abandonment or assignment might occur is sufficient. And in my understanding, it's simply because the patentee or applicant does not really suffer any harm when such an order is issued. It's just a balance of hardships, I would say, that is decisive in such cases. So I cannot say that register freezes are the only cases where an abstract risk is sufficient. There may be others, but currently it's the only abstract risk that has been acknowledged as sufficient by the Federal Patent Court for an ex parte order to be issued. Then another thing that was discussed is whether refusal to sign a cease and desist letter when a patentee sends a warning letter, whether that is sufficient proof of imminent risk of infringement. But clearly it's not. It's simply not. In the absence of any further indications, that's not sufficient. The next case that we discussed was a judgment of the Federal Supreme Court. That is case number 4A, 421 of 2022. The headword is Normalkraftanschluss. That is following up on the FPC proceedings between Schöck and Basis. That's a construction element. Technical details really don't matter here. But the issue there was that the Federal Patent Court acknowledged a prior user right of the defendant, but it dealt not with novelty over that previously used device for simple procedural reasons, because the corresponding request had not been on file by the defendant. And I will show you one citation from the Supreme Court judgment that I found interesting and that has been discussed at the event. It's marked up in yellow there. You can read that all alone, but it's a reference to Article 57 of the Code of Obligations, essentially saying that the court applies the law ex officio in the official English translation. That will be interesting to see what the Federal Patent Court now does with that guidance of the Supreme Court. As I said, it did not deal with a certain aspect of the case because a corresponding request was not on file. Now the Supreme Court said, well, you should have dealt with that and then remitted the case with reference to Article 57. The court applies the law ex officio. I've heard different readings of that remark of the Supreme Court during the discussions at the apero later. I've heard, well, it's only applicable in cases of an evident clash of the reasoning to prevent such clashes. The court should apply the law ex officio in such cases. But a different reading just gives the lower court pretty much leeway in dealing ex officio with maybe whatever they want, maybe not that broad, but it remains to be seen what the Federal Patent Court does with that. Now back to the event of 14th of September. What came to my mind is again the litigation between KFI and Nestle in view of this remark in the Supreme Court judgment that I just had on the screen. If you recall this litigation around coffee capsules, there the case was essentially about claim construction, as oftentimes, and the court was pretty firm in his opinion that, well, if you construe the term barcode properly, lege artis, then a bitcode is nothing more than a specific embodiment of a barcode. So a bitcode is a barcode. But that was not what the parties argued. They, at least I get that from the judgment, they both argued those two kinds of codes, a barcode and a bitcode, are different animals. It's not the same. So the judgment there said, okay, if you agree on that, then who are we? If that is not in dispute, then we don't need to decide that. Then we take that claim construction that you argue unanimously, and then the court went on with that claim construction and held, well, then there is no infringement. Apparently contrary to what the court's own opinion on claim construction was. Now, with the Supreme Court judgment that I had on the screen in mind, I wonder whether the Supreme Court would have said, well, if you are convinced of a certain claim construction, then you have to apply it, because you apply the law ex officio, and claim construction is a matter of law. That case between KFI and Nestle is currently pending at the Supreme Court. So it will be interesting to see what the Supreme Court will have to say in that case about the application of Article 57. The next case that took quite a huge amount of time in the discussion at this event was the litigation about deferasirox. That's a pharmaceutical case. It's all about the metes and bounds of the doctrine of equivalence in Switzerland in case of numerical ranges in the claim. Again, I won't enter into too much technical details, but to cut a long story short, the claim says you have between 45 and 60% of the active ingredient in a capsule, and the attacked embodiment contained 64.3% of that active ingredient, deferasirox. So, doctrine of equivalence in terms of numerical ranges, that's difficult, and it has been difficult also here. There was a judgment in summary proceedings already in December 2021. That was case number S2021-005. That judgment held it's an infringement on the doctrine of equivalence. And later in April 23, almost 1.5 years later, in ordinary proceedings, that is case number 2021-004, the Federal Patent Court issued a decision with an enlarged panel of 5 judges, actually reversing that finding and holding that this is not an infringement under the doctrine of equivalence. We discussed that a lot during the event. That case is currently still pending at the Supreme Court. I can't and I won't say much about that because our office is involved in that case. But it won't take long until the judgment of the Supreme Court will be published. Maybe I can even talk more about that in about a month's time. So it's about to be issued. Which brings me to the next topic that I have on my agenda, which is the complete re-election of the judges at the Federal Patent Court. As you know, they are elected for a term of 6 years, and the next term will be running from 2024 till 2029. And the current judges more or less ran again for re-election. I will come to that in a minute. But there were also some job postings for new judges, and the Judicial Commission had proposed these 4 IP people that I have marked up here. Susanne Finklenburg, she's working in industry, I think, if I'm not mistaken, at Mettler Toledo. Stefan Kessler is working with Keller Schneider in private practice. Lorena Pittico is also working in private practice with Isla Pedrazzini. And Susanna Ruder is again working in private practice. She's from our firm. So these 4 people were recommended to the Federal Assembly for election as new judges. As I said, almost all current judges ran again for re-election, except the 3 people on the left side, which are Christian Hilty. He was legally qualified judge. He is, till the end of the year, he of course still is. Peter Rickling and Werner Roshardt, they were both technically qualified judges. So these 3 are no longer judges at the Federal Patent Court as of 2024. And 2 further technically qualified judges will not be available for the full term of 6 years, but they will be retiring as judges in the second year of the next term. These are regular Lüdi and Kurt Stocker, both technically qualified judges. So, as I said, it was a recommendation for election, but this election was actually today, and I have learned 2 hours ago that the recommendation of the Judicial Commission has been followed by the Federal Assembly, so all judges have been elected as proposed. That's good to hear. I wish all of them, and especially the new judges, a lucky hand in reaching decisions, and of course much joy with this challenging task. Which brings me to a final remark on a personal note. That's about the file wrapper of the dossier or the patent application. I've discussed that with quite some colleagues, and I think I've mentioned that earlier on a few months ago for the first time. I once tried to get the full file wrapper by file inspection from the Federal Patent Office for an SPC application that has been refused by the Federal Patent Office. And that case then went up to the Federal Administrative Court. And after the decision of the Federal Administrative Court, again to the Federal Supreme Court. And at that time, when I requested file inspection at the Federal Patent Office, I was bold enough to request the whole file, including the exchange of briefs at the Federal Administrative Court and the Federal Supreme Court. And my reasoning was, well, the Federal Patent Office is party to those proceedings, they actually write half of the briefs that I requested, so they definitely have it, and they also are recipients as a party of the applicant's briefs in appeal proceedings, so they should have those documents. I requested them and I didn't get them. So yeah, it finally ended up with me filing an appeal at the Federal Administrative Court in order to have clarified whether that practice is right or wrong. I found that a bit strange that I can get and learn every detail of the first instance proceedings up to the first instance refusal, but that I'm totally in the dark for years while the appeal proceedings were pending. But yeah, be that as it may, the exchange of briefs in my own appeal proceedings is concluded. So appeal, answer, reply, and rejoinder, that's already done. So I'm awaiting the decision. If you want to watch the case number, it's B1281 of 2023. I will keep you posted also on that one. And yeah, that's what I had on my agenda for today. Let me have a look whether there are any comments on LinkedIn right now. No comments, but if you have any questions concerning anything that I have discussed today, or if questions come to mind later, feel free to leave a comment or direct send me an email. I will always be happy to enter a discussion also after the event. So that's all for now. It's pretty much on time, half an hour. So I hope you enjoyed the session and that I will see you again next month, as always, the last Wednesday of the month at 12:15 noon. Thanks for joining now and have a good lunch and bye-bye. Thanks for joining.